Welcome to the session on Employee State Insurance Act 1948. Normally we call it as ESI in short form. So this is an act to provide certain benefits to the employees in case of sickness, maternity and employment injuries, and make provision for certain matters connected thereto. This act is a unique one, really unique, because this is the only legislation insurance scheme in the entire world where there is no upper cap for treatment and other facilities. There is no insurance company which gives an unlimited coverage for any person, not only person, but his wife, children and dependent parents also. So in that way, it's a very unique part of legislation. In the entire world, this is a very unique scheme to start with. The feature of this scheme is that it takes care of permanent disablement and benefit for the widow for life in case of an accidental death, then hospitalization treatment for any disease even after retirement, non-employment coverage for a period of 1 year, free supply and equipment for physically disabled persons, and hospitalization and expense for spouse, children, including parents. So this is a very unique act. Initially, this act was made applicable to the factories employing 10 or more workers. It was made applicable. But subsequently, it has been slowly extended to various other areas of business activities, which includes even under the Shops and Commercial Establishment Act. And this feature of the scheme is that it is extended in a geographical limits, in the sense that it is applicable for a particular taluka or particular district of a particular state. Then it becomes all establishment located in a particular geographical location, the act becomes applicable. This is the way the notification will be carried out and the act coverage will go. Here, on account of the slower expansion of applicability act in various sectors, almost all the business sectors, business activities have been covered under this act. Here, the employee means a person who is employed for wages or in connection with the work of the establishment or factory, directly employed or employed by a contractor or through the immediate employer on the premises of the factory, and includes apprentices, including apprentice under the Apprentices Act, but does not include a person whose wages is exceeding 15,000 rupees per month. In other words, it has no classification for coverage. It means that anybody, even a manager, if he is getting a salary of less than 15,000, he is covered. No distinction has been made between various categories of employment here. Everybody is covered, provided the salary is less than the coverable limit of 15,000 per month. Now here, one important thing I would like to share with you is that under this act, a person who is an employee of the employer is an insured person within the meaning of section 214. The date of registration is not really material. The moment he joins the company on the first day, and if he just signs the declaration form on that day, he is deemed to be an insured person, even though his application has not been registered and no ESA number has been allotted or no contribution has been paid by him or by the employer. It doesn't matter. The moment he signs the declaration form on the first day, he is deemed to be an employee under the Act and he is eligible for all the benefits whatever available to him. In fact, in one case, the Supreme Court, in the case of Bhagat Engineering versus Ram Ranganaik in 2003, the principle has been upheld by the Supreme Court. In fact, the fatal accident, in the case of fatal accident happened in this case, and the widow claimed the compensation under the ESI Act, under the scheme. So the Supreme Court said that the case had to go up to Supreme Court to decide this issue. Supreme Court categorically said, the moment he signs the declaration form, irrespective of the fact he is paid the contribution or not, he is due to insured person, and all the benefits, whatever benefits available under the scheme has to be passed on to the widow. So this is how the employee coverage comes in the picture. Hence, in this case, always my advice is that ensure that the person signs the declaration form on the first day of his employment, because we don't know what's going to happen on the second day or the first day. So to be on the safer side, you must ensure that you get the declaration form on the first day. Person directly employed, yes, no issues. Person through contractors, yes, they are covered. Casual employees, they are also covered. Part-time employees, they are also covered. Trainees, apprentices, including Apprenticeship Act, they are covered. And home workers, they are also covered. I will explain what is home workers. Then persons engaged for loading and unloading through contractors, they are also covered. Now, first of all, what do you mean by immediate employer? Immediate employer is nothing but a contractor, nothing but a contractor. In relation to employed by through means a person who has undertaken execution of work in a premises of the factory and an establishment, and under the control and supervision of the employer or the agent. This is very, very important. Under the supervision and control of the principal employer, hold up or ordinarily work in the factory or establishment principal ordinarily or primarily to work carried on incidental purpose for such factory or establishment, and includes any person by whom services are employed who can enter into contact with him or temporarily let in or let out on hire to the principal employer, and includes a contractor. It means that it gives a very, very wider meaning in this context. It be immediate employer nothing but a contractor, but includes a contractor also. Immediate employer the workers he supplies, but it is the supervision and control of the principal employer. This is one immediate factor. Whereas the contractor, it can be both. It can be the supervision and control of the contractor, or it need not be also. But in the immediate employer, this is the position. So in other words, they are also covered in this act. There are some interesting cases, I will take it forward. So if you see the close examination of the immediate employer, we find that the employee is employed through whom means a person who has undertaken execution of work in the factory premises and includes work carried out by an immediate employee contractor under the supervision of the principal employer or his agents. This means to conclude that if the work is carried out by a contractor whose work is not supervised by the principal employer, do not fall under this supervision, under this definition. Hence, many times arising out of this, the liability of the principal employer under this does not exist. So this is a very peculiar thing. If he is not supervised by the principal employer, then the connectivity between the principal employer and the immediate employer will not be there. Then the liability of the principal employer under this act does not exist. So this is a peculiarity in this particular definition. So in fact, in one of the cases in Bombay High Court has said that Abu Marwan Mining versus ESIC in 2005, they had that principal employer was not supervising the workers of the contractor, since no liability for contributions can be fastened on him, because since the supervision is carried out by the contractor, he is an independent employer by himself. Since the principal employer cannot be held responsible for the default of the ESI contribution on behalf of the contractor. In order to develop the determined relationship between employer-employee, between the principal employer and the employees against the contractor, supervision by the principal is essential. In the case of CSSC Limited was Subhash Chandra Bose in 1992, Supreme Court has wrote this. Again, same thing. In National Labour Works, maybe Madhya Pradesh High Court has said that an employer not supervising the work of contractor employees will not be liable for their contribution. So this is a very, very important point to be noted down, that if the contractor does the supervision and control of his contract labor in the establishment, the liability on the principal employer is totally minimized. So this is the issue of this. Similarly, a contractor who is engaged in connection with the work and also deemed to be a contractor work amounts to notional extension of factory. For instance, we outsource certain activities outside the premises, but that work is supervised by the management or its agents. Then what happens? It becomes a notional extension of factory. It means that whatever the components are to be manufactured in the plant, you are manufacturing in a separate shed under the guise of the contractor, but the principal employer is supervising it. Hence, this amounts to notional extension of factory, and principal employer will be held responsible for the coverage and other liabilities under the ESI scheme. ESI Act is a very, very complete code by itself and applicable to all employees of the concerned employer. This applies to the people who are employed in the office, not only employed in the office, but who work outside also. Now, for instance, there is the case of a company who services air conditioners in a particular city. Their area of work is spread out everywhere. So, where it is the fact that the servicing of air conditioners will be carried out by his people at different locations, even outside the state also. So, primarily it is the job of the main principal employer, air conditioner, to carry out everything. Hence, they cannot say that they are not covered under ESI. It has to be covered, even in spite of the fact he works outside the office premises, but he yet to be covered because the work is carried out by him. He is in connection with the main work of the employer here. This is how the argument is taking place. Exempted employee means an employee who is not liable under this act. It means that his salary is above the limit of 15,000 rupees, he is an exempted employee. Factory means exact definition of factory holds good here also. We discussed the definition of factory when we discussed the Factories Act. It consists of precedents and the manufacturing process. These are the two main criteria. If these criteria do fulfill, then it's a factory and ESI Act automatically becomes applicable. In fact, all the decided cases, what I quoted when we discussed Factories Act, here also the same thing, the manufacturing process, usage of power, everything comes here, and the courts have held that it amounts to factory and ESI Act becomes applicable. In fact, in one of the case, one of the person in North, maybe in Jaipur, one person was making preparation of jalebi for his customers. He was employing more than 20 people and using LPG gas for cooking. So, when the ESI inspector went there and he made an inspection, he said, it amounts to factory and you have to cover it by ESI. This matter went up and ultimately held that jalebi making amounts to manufacturing process because the number one process, number two is usage of LPG, then it's a factory, then ESI has to be covered. So this is another extreme example of the coverage. Then usage of LPG, usage of steam, electrical energy, everything comes in the picture. Examples are, for instance, petrol pump, because pumping activities, kitchen cleaning and cutting vegetables, dry cleaning, washing, it's a process, storage of milk, it's a process, a bakery, because they use usage of slicing machines and also is a process, etc. These are some few examples where the coverage takes place. Now, wages means here, it's all inclusive. In the sense, all remuneration paid or payable in cash is wages. Then only exclusions are the contribution paid by the employer to pension fund or provident fund, any travelling allowance or value of any travelling concession, any sum paid to the person employed to defray certain special expenses entailed on account of the nature of employment, and gratuity payable on discharge. With these exceptions, whatever the money amount paid to him, it's wages under the definition of ESI Act. Now here, the definition of wages has always been a subject matter of judicial interpretations. Various courts, including Supreme Court, have given number of citations on the matter of wages, because number of issues have been taken up to the courts, what is wages and what is not wages. Now I have prepared a comparative slide, and you can see in the slide, on the right side you will find to be deemed as wages, on the left side you will find not deemed to be as wages. I have taken these points from various judgments. Instead of quoting all the judgments, I have just compressed it in the form of a small table where you can read and understand what is deemed as wages, what is not deemed as wages. Deemed as wages obviously is very clear: basic wages, dearness allowance, house rent allowance, city compensatory allowance, overtime wages, and then payment for delay, day of the cause, day of the rest, and production incentives paid every month, and bonus other than payment of bonus under payment of bonus act, shift allowances, travelling allowance, any kind of allowances. Not deemed to be wages is contribution paid payable by the employer towards PF and ESI. Some paid to defray certain expenses. For instance, we give welding allowance, what called shoe shine allowance for security. All these kind of allowances are excluded from the definition of wages. Gratuity payable on discharge is not. Pay in lieu of notice of retrenchment is not wages. Encashment of leave, it is not deemed as wages. Payment of inam, which does not form part of terms of employment, is not wages. Washing allowance for livery is not wages. Similarly, washing allowance, incentive bonus paid, if paid more than 2 months interval. If the incentive is paid in the interval of more than 2 months, then it is not deemed as wages. If it is paid every month, it comes as wages. Then annual bonus, annual commissions, all things are not deemed as wages. On the other side, the inclusive of wages is very much city council, conveyance, suspension allowance, substance allowance what we pay, then layoff compensation, then HRA, shift allowances, wage paid for the unsubstituted holidays, interim relief, etc. All things comes as wages and deemed wages. So you can have a glance at this and you will understand the extent of interpretation by the various courts in the wages. Now here coverage, if there are more than 10 or more persons in the establishment, it's covered. When you calculate 10, you have to cover, you have to count all the persons employed in the establishment. Including the contract labor who are engaged in the establishment, you have to take into account. If the number exceeds 10, you need to cover them. There is no provision for voluntary coverage by employer if he is less than 10 persons. There is no provision. So he has to cross 10, then only it becomes applicable, otherwise no. In case the head office and corporate office is covered, naturally the branch offices, godowns and warehouses, etc. are automatically get covered. Another thing is, once an establishment is covered, the coverage will continue even if the number falls below 10. It continues. Here the payment of contributions is 1.75 from employees, 4.75% from employers' contribution. Then it is submitted before 21 days from the close of the wage period. Then other format, the declaration form. Then payment of contribution online, general monthly ECRs, temporary ID card, photo ID cards, and accident information to local office. All these things have to be complied with. So contributions of both employer and employer to be paid at ESI as stipulated. In case of any delay in remittance, we will call for levy of interest at 10%, and if it is a delay in remittance, not only payment but also ESI can claim damages also in this respect. Here one provision is there under section 40. This stipulates that for the first instance, the principal employer has to pay the contribution payable to him, by him, and also through immediate employer. Under no circumstances deduction from the way from towards employee share of contribution. The principal entitled to recover from the immediate employer. It means that in case of immediate employers, it means immediate employer, I told you already, the contractor, the contract labor who are working under the supervision of direct supervision of the principal employer or his agent, they are immediate employers. In their case, the ESI says you have to pay the contribution of both the contract labor under immediate employer and the regular workers. You have to pay at one stroke, and then you can recover from bill in the subsequent stages. So the responsibility is put on the principal employer. Of course, here I have made certain comments on this particular section. The immediate employees and contractor are also entitled to register and obtain ESI code numbers, because they are also independent establishment by themselves. Because when they apply for ESI registration, ESI code, they need to submit as if they have got an independent establishment of their own. So what happens is that they submit the documents, just like the principal employer also submit the documents to get the ESI code number. The formalities are same. Hence what happens, all documents pertain to the establishment he has to submit. Like for instance, his certificate of registration of the Shop Act, and then his articles of association, his partnership deed, or list of directors and their contact number, any board resolution taken for coverage of employees under ESI, and list of employees maintained by him, the salary register maintained by him, all things has to be submitted by him to the ESI corporation as if it is his own independent establishment. When that is the case, he is an independent person. So the question of paying the contribution by the principal employer under section 40 is not relevant now. Because all the contractors, all the immediate employers will do the same thing and there is no relevance. But there is one important thing. If the immediate employer or the contractor is not able to get the code number because his strength is less than 10, then you can't help it, the principal employer has to comply with section 40. If the contractor, immediate employer, takes the independent code number and submits it, any fault or delay on the part of the immediate employer or the contractor, the liability on the part of principal employer naturally comes down and he can get out of the issue. So here, the courts have held that independent code number, they treat as separate establishment and required to follow all the opening rules. The risk and consequences of non-payment is considered highly minimized and even eliminated also. For instance, now in the case of, in Supreme Court, in the case of Steel Authority of India, National Workers Union from 2001, they have said the scheme of Contract Labour Act stipulates that the principal employer will not be supervising the workers of the contractor, otherwise the contract labour system will be rendered as sham, ruse and camouflage. So here, the important thing is, if he is not supervising, then the question of the connectivity of contract labour with the principal will not come. In the case of Pradeep Kumar, presiding officer, the High Court of Punjab and Haryana has said that employer-employee relationship in respect of would not exist if the employer engages supply of manpower in having valid license with CL and Contract Labour Act, and records of payment of wage attendance show payments made by the contractor, EPF from allotted to the work through the firm of the contractor, then principal employee doesn't exist and principal employee is not liable under these circumstances. In the landmark judgment in the case of Food Corporation of India versus PF Commissioner, the Supreme Court has observed that it is indeed a large amount of determination which a commission has to only depend on list submitted by the workers' union. It is no doubt true that the employer and contractor are both liable to maintain register in respect of workers employed, but the corporation seems to have some problem in collating list of workers since they are scattered across the country. The commissioner did not summon the contractor, the appeal was allowed. It means that here also, even the Supreme Court recognizes the fact that the contractor is bound by all the terms of the Act and he has to act upon. In one PF matter, in the matter connected to the Provident Fund, in the case of Madurai District Cooperative Bank versus APF, they have held that if the contractor has got independent code number, the principal employer cannot be held responsible for the default or delay in remitting the PF contribution in respect of the contract labour engaged by him. The same argument will hold good in this case also. Similarly, in the case of Group 4 securities, same thing has happened. In the case of Bricks India in Madras High Court in 2015, the same principle has been upheld. So applying these principles, we can definitely say that if the contractor has got independent code number, the liability on the part of the principal employer is highly minimized. So this point you need to bear it in mind, and please ensure that the things are followed up with the immediate employer and employer. You should try to collect all the required information and data from him to establish that he is an independent establishment by himself and making services for you. Next, the difference between contribution period, benefit period. All of you know that contribution period is April to September, whereas corresponding period will be January to June. Then October to March is the contribution period, benefit period will be July to December. There is no time limit for recovery ESI contribution. Here, the question of Limitation Act will not apply here at all. In this sense, the obligation to pay the contribution imposed on principal employer right of the recourse is created by statute do not exist independent statute. Either by resort to section 4 or therefore right to recover contribution would not in effect by law of limitation. Hence, the Limitation Act is not applicable. So the recovery of contribution can be initiated by the corporation at any point of time. Then deposition of ESI contribution do not depend on the disbursal phases. No one can take a contention saying that I have not disbursed the salary yet, so I will not pay the contribution to the corporation. No. The moment the wage period is over, the moment the amount becomes payable, irrespective of the fact whether when you pay, you have to remit the contribution within 21 days we close the wage period. The workers engaged in construction repairs and maintenance through contractors. Now here, in many situations this happens because in a factory building, we engage workers for construction, repairs and maintenance of workers through contractors. Maybe painting, maybe repairing, maybe reconstructing, and maybe furniture repair, whatever the types of work, it will be normally given to some contractors and they carry out the work and then go away. Then by law they are also covered under the ESI scheme, ESI Act, because they happen to be the contract workers. They are the workers under the ESI scheme, ESI Act. Then what happens to the contribution period, or what are the contribution payable? If the principal employee is not able to bifurcate the exact wages paid by the contractor to the contract laborers, the court has laid down the principle saying that on the total invoice, you assume 25% as the labor charges. On 25%, the contributions of both employers and employees have to be remitted to the corporation. So 25% on the total invoiced value. This is how the thing is said. In the case of, in Supreme Court also has said the same thing, and in Sundaram Clayton in 2004, they have reiterated the same stand. And even in case of Madras High Court's Gokak Mills case also, the same principle has been upheld. Now here, I have collected some contingencies, just for information I would like to share with you on different contingencies. The contingencies are like this. Supposing the job work is done inside the factory premises or established through contractors who have independent code number, then there is no problem because such contractor work required by the respective employer, the subcontractors, then the question of principal employer doesn't arise. But to be unsafe, the principal has to oversee whether the contribution is remitted by him or not. Then second scenario, the job work done inside the premises through contractors but not having independent code numbers. Then the principal employer has to cover them under his code number, and you have to cover and pay the contribution, and you can recover the money from the contractor's bill. The next scenario is job work done outside the factory or establishment through factories or establishments have independent code numbers. Then there is no compliance required by the principal employer because they themselves are independent factories having different code numbers, they have separate code numbers. Obviously, Also, this is very important. Please note this provision. Under this Act, ESI courts are established under the Provisions Act. Only these courts have jurisdiction to deal with and take up all cases and disputes between ESIC and employers in connection with the Act. The civil courts are totally barred from interfering in any matters in connection with the Provisions of this Act. Only ESI court has the jurisdiction, they have to take it. Now the question of employment injury. Employment injury, it says that any accident arising in the course of insured person's employment shall be presumed in the absence of evidence contrary also have arisen out of that employment. It means that an employment injury is an employment injury arising out of employment and in the course of employment. So when it becomes an employment injury. Now section 51 says accident happening while travelling in employer's transport. Then what happens? The accident happening while the insured person is travelling with express or implied permission from his employer, travel in the bus, transport provided to him, and if means accident, it amounts to an employment injury. And occupational disease. If an employee employed in the employment specified in Part A of third schedule contracts any disease specified therein, or an employee employed in the employment specified in Part D, Schedule 3 of the employment for a period not less than 6 months, or if the employee in the employment specified in Part C of third schedule for a period notified with corporation, unless the conduct shall be deemed to be employment injury. See, this is nothing but what you call an invisible injury. Occupation is nothing but invisible injury, because we do not know, we do not see the visibility of the injury, because it catches after a period of time. It can be 6 months time, it can be 1 year time, depending on, if you refer the schedule, third schedule, second schedule, you will know very clearly the periods have been mentioned. And if he catches any of the disease specified in those schedules, it amounts to employment injury. That's called nothing but occupational disease. Now, since ESI is covered, it's a comprehensive scheme. It takes care of all the compensation payable or damages arising out of the employment injury to his family or to him. It is purely the responsibility of the corporation. Here, the law prohibits the insured person or his family members to raise the claim before in any other forum, including the Workmen's Compensation Act. The court there is a total bar against receiving or recovery of compensation under any other law. You cannot go on and file a civil case after having received ESI compensation. Or if even though you are not claimed ESI compensation, if you are an insured person, you cannot make a claim even under the Workmen's Compensation Act or even under the Civil Code for any tortious liabilities. The law is very clear, it bars. It means that if you are an insured person, you have to claim your damages only under this Act and no other Act. This is very, very clear. Of course, this has been upheld by Madras High Court in the case of Tangappan versus TN Insurance Company. And also in the case of Supreme Court also has upheld the same thing in 1996. In Tehran case, they have held very clear, ESI Act is a very clear one, has got a wider coverage. It is more comprehensive. It provides more compensation than Workmen's Compensation Act. The compensation is more substantial. Hence, the bar is created against claiming the Workmen's Compensation Act or any law. In view of the clear language of the section, there is no justification in interpreting or construing it is taking away the right or both. So Supreme Court has said very clearly, it means to say that the insured person cannot go to any other court to claim remains except under ESI. Similarly, of course, the same Supreme Court in the same case also had repeated the same argument here also in the case of Western India, plywood versus Ashokan in 1998, same thing has been repeated here also. Of course, if you do the benefits at glance, there are benefits like medical benefit, sickness benefit, then extended sickness benefit, then enhanced sickness benefit in case of continuous sicknesses, then maternity benefit, then disablement benefit, then under that permanent disablement benefit, then dependence benefit in case of death. Then there are other expenses, other benefits like funeral expenses, then confinement expenses, then vocational rehabilitation and old age care, medical care, then artificial limbs and aids. This is an interesting feature in this scheme, that the contributions are paid at a fixed rate in percentage of age, whereas they provide social security benefit according to individual needs without distinction. Artificial limbs and aids, you know that it's a very expensive equipment, but ESA provides that absolutely free of cost because of the contribution made by him and covered with the Act. Then further also they extended, for instance, Rajiv Gandhi's Shramak Kalyan Yojana they introduced in 2005. When unemployment allowance equal to 50% wages for a period of up to 1 year. Then medical care for self and family from ESI hospital during the period IP receives unemployment allowance, that benefit is available. Then vacation training is provided for upgrading skills, is also provided. Then minimum wage for physically disabled person for availing ESI benefits is 25,000 rupees. So this is an advantage in the sense that for physically disabled persons, the wage limit is 25,000. For others it is 15,000. Here it is 25,000. So we want to ensure that the physically disabled persons, they get covered under the ESI scheme, even though their salary bracket is more than 15,000 but less than 25,000. Then here the employee's contribution is paid by the central government for 3 years. We encourage the employers to recruit disabled persons in their employment. An incentive is shown by the government that the central government shall reimburse the contributions of such employees for a period of 3 years. Now, when an accident, a person meets with an accident, while coming to the place of work, can be treated as an accident or not, is a question. The ESI Act was amended in the year 2010. The amendment has said very clearly, any accident occurring from the place of his residence to the place of work and place of work to his residence, of course he should take the normal usual path. If any accident happens in between while coming and going back, it is treated as employment injury and she is eligible for all the benefits, because this is called notional extension theory. The notional extension of employment, that theory is pronounced, and accordingly he gets the benefit out of this. Now, how conviction of an employee affects his benefits? You see, what happens is that the employee also can many times mislead the corporation, and to take the benefit he takes it, and in case ESI convicts him in a court of law, then he is not entitled for any cash benefit under this Act for a period of 3 months for the first conviction and 6 months for his subsequent convictions. This is very clear. Then how strike affects employees' benefit? If the workers go on strike, how it affects? The Terms of Provisions Act makes very clearly, if an employee remains on strike and is not entitled to any sickness benefit or disablement benefit on any day when he remains on strike. So it means that if a person is on strike, he is totally barred from receiving any benefits and including sickness benefit. Is there any provision for exemption of factory or establishment ESI coverage? Yes, there is a provision. If the employees of the factory establishment who are in receipt of substantially similar or more benefits than were under the ESI Act, then on an application made by such employer, the state government may grant an exemption. So the conditions are very clear. The benefits and other things, what is given to the employees, should be more than the benefits given by ESI scheme. Then in such case, the exemption is possible and he can take the exemption. And how a temporary or casual employee who works for 3 to 4 days leaves the employment he is entailed for medical care. Sometimes what happens, we engage people for, maybe he works for only 3 or 4 days and he gets back or he doesn't turn up. Or we engage him only 3 or 4 days and then we may discharge him. And he works only 3-4 days and then goes away. In such case, if an employer gives certificate of employment, then what happens? His family, the person and his family can avail the medical benefit for a period of 3 months. So this is an advantage available. Provide the certificate of employer, the family, he and his family can get the medical benefit for a period of 3 months. So this is a very, very added advantage. Then how to get the medical benefit insured person leaving out of for other station for temporary employment? Now of course you know that we have got smart card facilities. Under this he can go to any dispensary anywhere in India and take the treatment, no problem. And similarly, in case of insured family also, if they are residing somewhere, an employee is somewhere, the family also can get the same benefit, same treatment, etc. based on the smart card issue across the country. Now under this, what are the benefits available to the employer who are covered under the scheme? If it is covered, actually the employer is getting the employee protected under ESI in all respects, because he need not worry about any issues related to health, sickness, accident, disability benefit of the employee once he pays the contribution. The employee is relieved of providing any medical care to the employee and his family. He is totally relieved of that. Then employee is relieved from the payment of maternity benefit to women who are in the state of Maternity Benefit Act. Because maternity benefit, the ESI will take care of it. The employer need not worry about it. And the employer's share of contribution is exempted from income tax payment. So these are the advantages the employer is able to get it. Of course, here the benefits available admissible family members are already explained to you. The family members are also entitled to full medical care needed. Family members also entitled to all artificial limbs, artificial appliances as a part of medical treatment. Then medical benefit are also admissible to the family during the period of insurance, a receipt from employment allowance, then reimbursement of expenditure incurred on funeral expenses. And in case of death of insured person due to employment injury, the spouse and widowed mother and children are also entitled for dependents benefit. So any benefit due to the insured person at the time of death is paid to the nominee. So these are the few benefits. And either the provision for exemption from payment of contribution. There is only one exemption, is that I told you already, that to encourage to employment of disabled persons, employer is exempted from payment of employer's contribution for a period of 3 years, and central government will take care of it. This is one important thing. Temporary medical benefit is suffering from disability employment injury for a period of absence from work and resume normal at the rate of 150% of standard benefit rate, which is 75% of his wages during the period, he is going to get the employment temporary disability benefit. Then similarly, he will also get permanent disablement benefit as per the rate specified. Dependent benefit is the monthly pension payable to the eligible dependent persons who dies as a result of employment injury or occupational diseases. Then temporary disablement are also admissible in case of casual or temporary employment with an accident injury on the first day or any day before he completes the contribution period. No, the qualifying condition contribution periods are attached to temporary disablement benefit and permanent benefit and disability. If he meets with an employment injury on the very first day of his joining, the benefit is admissible. So in short, this is about the ESI scheme. I tried to highlight the important aspect of the scheme and the important legal intricacy involved in the scheme and the benefits available to the people under the scheme. So with this I conclude. Thank you.